Good evening, SASLAW members, wherever you are. We see that we have most of our attendees logged on already from across the country. This is, of course, a hybrid event, so we have some of our local members with us here at the Club Chambers in Port Elizabeth. Craig Bosch is on standby in Cape Town, ready to present our talk, and a warm welcome from the Eastern Cape chapter. By way of introduction in relation to Craig, I think I should start out by saying that he's the victim of entrapment of sorts, in the sense that I came across him in the Labour Court a number of months ago, and while his mind was understandably preoccupied with concerns about the case that I had to argue against us, in a moment of absent-mindedness, I asked him whether he would on some future occasion come and be our guest speaker at an Eastern Cape seminar, and he absent-mindedly said yes, and in due course the call came, and under those circumstances he could hardly decline. So Craig, welcome back to the Eastern Cape. You've been kind enough to be our speaker on a number of occasions. Craig is, of course, a respected academic. He's, for the last number of years, also been a respected counsel attached to the Cape Town Bar. He's a leading figure in South African labour law, and it's my pleasure again to welcome him to our Eastern Cape chapter event. And with that, I'm going to pass straight over to Craig Bosch. Thank you very much.
Thanks, Francois. I'm glad to be back, and I'm also sorry that I can't be with you all in person, given the current constraints that we're operating under. And just for the record, we won that case that we were arguing against you in the Labour Appeal Court in PE, so clearly I wasn't too absent-minded on the day. I'm going to be talking this evening about Section 197 of the LRA, and really, Francois invited me to do a kind of Cook's tour of recent developments in the application of the section in various contexts. And there has been an interesting evolution in some respects, particularly around outsourcing and insourcing. But also some of the old themes are still prevalent, and we'll see how that unfolds as we go. I've cobbled together some slides, which I'm assuming you can all see at the moment. I can't claim that they're any kind of work of art or of great intellectual property content, but they'll serve their purposes for this evening. I think it's worth starting with the purpose of Section 197. It was introduced when this was first discussed by the Constitutional Court in Nahawi. The court said, you know, Section 197 has a dual function. It's partly to serve the interests of employees, to protect their jobs and give them security of employment when their jobs shift from one employer to another. And secondly, it's also to serve the interest of employers, in the sense that when employees are transferred, when the business goes, employers don't have to be saddled with the burdens associated with retrenching employees. They can just seamlessly move from one employer to the other. And I've given you a quote from a more recent decision in the Constitutional Court, where the judge said that the focal point of 197 is to protect the employment of the workers through the hands of whom a service or goods are supplied. Their contracts of employment get transferred together with the business or entity that provide a particular service. And the essence of it really is, if the business goes, then so should the employees. Could I have the next slide, please? I see. Thank you. Oops, there we go. I've headed this what we know, because I think many people are confused about the application of 197 and view it as a bit mysterious and something that generally people don't know very much about. The principles are fairly clear now. They've crystallized out quite nicely over the years. And so what we can say with some confidence is that 197 and 197A apply when there is, firstly, the transfer of a business as a going concern, and those things look fairly innocuous put on a page like that, but come to their application and things start getting tricky. Next slide, please. Thank you. So the application of those factors is an objective one. It's not about what the parties want or what they think is going to happen in a particular context. It's not enough, for example, to put in an agreement that this is a 197 transfer and think that will constitute a 197 transfer, or to put in an agreement that is not a 197 transfer and think that that will suffice. It's really about what the facts speak to in the particular context. And I thought this quote from the Labour Appeal Court's decision in TMS Industrial Group sums it up quite nicely. There the court says, and it made the point repeatedly about how fact-specific the 197 inquiry is. And the court says here clearly the demarcation between those cases which are deserving of protection under 197 and those which fall outside of the protected scheme are dependent upon a comprehensive engagement with the specific facts of each case. And my experience in practice in trying to advise people around the application of 197, where the consequences, if you get it wrong, are often very serious, is that the devil is in the detail. The devil is in how you take the fairly clear general principles and apply them in the context of particular circumstances. Next slide, please. Thank you. So if we can talk about what is a business, and I'll give you sort of a general trawl through the principles. What is a business for the purposes of 197? Well, we know that it's defined, and the definition, perhaps fairly unhelpfully, says that a business includes any business, trade, undertaking or service. And the courts have said, well, a business as far as 197 is concerned, drawing on European authorities, is a defined set of activities which represents an identifiable business undertaking. We do know from recent authority in aviation union and rural maintenance in the Constitutional Court that a service in and of itself doesn't constitute a business. So the sort of the capacity or the right to provide a service to a client, which may shift from one service provider to another, particularly in the context of outsourcing, doesn't in itself constitute a business. Something else is required. The Constitutional Court says this means that it's the business that supplies the service, the business entity, I would suggest, that supplies the service and not the service itself that must be transferred. Could I have the next slide, please? And here's from a fairly recent Labour Court decision in the Mvula Quality Protection matter, where the court said the relevant inquiry is into the existence or otherwise of a discrete economic entity in the form of the variety of components that go to make up a business, including assets, goodwill, workforce, management staff, and the manner in which the business is organized and performed, the operational resources available to the business, and the like. And this gets particularly tricky in the context of 197 sometimes because business includes a business or part of a business. And the difficulty arises in how to ring fence what constitutes part of a business for the purposes of 197. So what we ought to be looking for is something which is discrete, but comprises a variety of components, sort of the usual components that go into making up a business, including the various things which are listed in this quote. Okay, next slide, please. So as far as a going concern is concerned, if you'll pardon the pun, this is nothing new. I was quite struck today when I realized that Nohaba versus UCT was decided in 2003. It starting to make me feel like I've been in the business for a long time. So I remember much excitement being generated about this decision and how it sort of set a number of important principles in the context of Section 197. So here the court tells us, and this has been reiterated time and time again in the various cases, that in deciding whether a business has been transferred as a going concern, regard must be had to the substance and not the form of the transaction. If so, what is the effect of the transaction as opposed to how it happens? And a number of factors will be relevant to the question whether a transfer of a business as a going concern has occurred, such as the transfer otherwise of assets, both tangible and intangible, whether the workers are taken over by the new employer, where the customers are, and whether or not the same business is being carried on by the new employer. What must be stressed is that this list of factors is not exhaustive and that none of them is decisive individually. Now, the immediate question that arises there is whether some factors are more important than others. So, for example, if one runs a bus company that's providing a service to a municipality or to a city, and a new contractor comes in to take over and provide that service, but doesn't take over the buses, whether that can constitute the transfer of a going concern. Does the new business look sufficiently like the old business that one can say that it's a transfer as a going concern? Could I have the next slide, please? So here the court says, or what emerges from the case is that it's not required that all the assets or employees of a business need to be transferred, but what must be transferred are those assets and personnel that are essential to the business as it was operated by the transferor. So yes, some factors or parts of the business are more important than others. You must be put into a position as the new employer that you can carry on the business effectively as it was carried on by your predecessor. And I've given you a quote from the Constitutional Court's decision in rural maintenance, where the court says that without the transfer of the means to do the work as they did as part of rural's business, there could be no transfer of the business to the municipality as a going concern. The assets that rural did not transfer back to the municipality were essential to the profitability and operation of the business. Without those crucial assets, the municipality could not have carried on the business without any major difficulties. Now, in that case, the municipality had outsourced to rural maintenance various of its operations and functions relating to the provision of electricity. And what had started out as a fairly rudimentary operation that expanded into something fairly significant. I think they moved from 27 to 100 and something employees. Rural maintenance acquired a significant number of quite expensive assets and equipment. And a lot of that did not go back to the municipality when the municipality terminated the contract with rural and took on the provision of the services itself. Just incidentally, Francois did ask me to touch on, and I will only touch on it, the application of 197 in the context of transfers by state organs or state entities such as municipalities, and whether it applies perhaps overriding or taking precedence over some of the legislation regulating local governments. And then what emerged from this decision in rural maintenance in the Constitutional Court is that Section 197 takes precedence. You're no doubt familiar with Section 210 of the Labour Relations Act, which says unless it's specifically provided otherwise, the provisions of the Labour Relations Act prevail over pretty much any other legislation, and that was certainly the case here. Okay, just next slide, please. Yeah. And then just, it's worth making the point, I think, particularly in the context of outsourcing, perhaps, that there needn't be any agreement between old and new employers regarding the transfer of a business from one of them to the other. There doesn't have to be a contract between them necessarily, and in some of the cases it's become quite apparent that there needn't be a written agreement. It's sufficient that there's an understanding between the two employers, excuse me, that business will transfer from one to the other in some way at some point. So if we could just go back before we move on. Thank you. This is particularly prevalent or perhaps important in the context of outsourcing, where there often isn't an agreement between the outgoing contractor and the incoming one. They're in all likelihood entities that don't want to have too much to do with one another if they can help it. The outgoing contractor has lost the contract to the incoming one. There's probably no love lost between them. There's not going to be any agreement or arrangement between them relating to the transfer of employees. So to require one in circumstances where there is in all likelihood very clearly a 197 transfer, would be to go some way to defeating the application of the section. The practical problems with that are perhaps something that people can share in the course of questions or discussions. Once I'm done, or even during the course of this discussion, if you'd like to put up questions now. The idea that employees don't know what's going on as far as the transfer is concerned, there's no information provided to them as a requirement. The fact that the incoming contractor doesn't know very much about what employment obligations it's assuming on the part of employees that it's taking over by virtue of 197. And it's perhaps worth making the point that in other jurisdictions like the United Kingdom, for example, where they have fairly detailed and long experience in applying their transfer of undertakings, protection of employment regulations, that there are specific regulations dealing with information that must be provided by outgoing contractors even before the transfer has been determined, even before the new contractor has been appointed, so that people coming in circumstances where their equivalent of 197 might apply will know what they're taking on as far as wages of employees are concerned, the benefits are concerned, perhaps potential obligations for claims relating to dismissal or unfair discrimination, etc., etc. In South Africa, we, as new employers, take those things on, but perhaps unless one does proper due diligence, don't know always what it is that you're going to be in for. Okay, if I could have the next slide, please. So I thought what I would do is start looking at some of the useful and interesting cases, and I've particularly have found that the Labour Appeal Court decision in this TMS Group Industrial Services versus Unitrans Supply Chain Solutions quite useful, and it goes some way, I think, to expanding Section 197. I think realizing its proper application in circumstances such as those which prevailed in this case. So this was a case where the outgoing contractor had been providing warehousing services, so effectively running the warehouse of the client. And interestingly, it used the services, the outgoing contractor was responsible for the services, but used the labor of employees that were supplied to it by its own wholly owned subsidiary. So you had sort of Unitrans something and then Unitrans something else, who was the second respondent that supplied the workers, and it became an interesting debate around who's the old employer in these circumstances, because the outgoing contractor is the person who's responsible for the services, but it's not the person who, at least on the face of it, employs the employees. So even if there is something that looks like a 197 transfer, what happens to those employees? Now, it was clear that the second entity, the wholly owned subsidiary, was not a temporary employment service, and the employees only did work on this particular contract. But in rendering its service to the client, the outgoing contractor used assets which in the main belonged to the client. So that the premises at which the work was being provided, the IT systems, the forklifts, the furniture, the computer systems, etc., all of that belonged to the client, and it was managed and utilized by the outgoing contractor, but didn't belong to the outgoing contractor. Of course, inevitably, that contractor lost the contract is put out to tender, a new contractor comes in, and the outgoing contractor says, well, you know, congratulations, 197 applies, you've inherited a ready-made workforce, which the incoming contractor might not have been anticipating, or at least didn't want in this case. They say, well, this is not a 197 transfer. And in making that argument, they rely, as I've indicated there, on this quote from the aviation union matter in the Constitutional Court, where the court said that for a transfer to be established, there must be components of the original business which are transferred onto a third party. Those may be in the form of assets or the taking over of workers who are assigned to provide the service. So the transfer of the service is not in and of itself enough. This provision of the service of warehouse management. And the incoming contractor says here, well, we're not taking over anything. We're not taking over anything from the outgoing contractor. Everything that we're going to be utilizing belongs to the client. And so section 197 can't apply. Now, you can imagine that the effect of that would be fairly far-reaching, because it happens often that, for example, people are contractors are providing services, catering services to universities or businesses, for example, and that contract is lost. They're using the kitchen and other utensils and other facilities of the client. The incoming contractor comes in and literally steps into the shoes of the outgoing contractor. But 197 didn't apply there, and something which looks classically like the same or very, very similar business, again, the operation or the purpose of the section would be defeated. So the court rejected this argument, saying, if we go to the next slide, that the necessary facilities were handed over to the appellant in this case, in a state in which the appellant was able to carry on the very same activity which had previously been conducted by the first respondent. It performed those services on the premises of the third respondent. It employed third respondent's computer systems and other equipment and carried on the same activity of warehousing, and I just put in there, so it equals a transfer as a going concern. So the point is, and I think it's an important one, that it doesn't matter if the various components of the business that has been identified, this discrete bundle of business bits, if you can call it that. It doesn't matter if they don't all or some don't belong to the outgoing contractor. If they end up, or most of them end up, of those components in the hands of the new contractor, then that's sufficient to trigger the application of 197. And that's what happened here. So the court was quite ready to accept that after the shift from the outgoing to incoming contractor, what you were left with here was essentially the same business, but in the hands of somebody else. As far as the employees are concerned, that were provided by this second entity, and the court was quite ready to accept that the service provider, the main contractor, who was responsible for the services, was the real employer, and it's sort of the guiding mind in determining the fate of the employees, and was of the view that if the submission was to be upheld, that this second entity should be regarded as the employer, and 197 couldn't apply because it wasn't transferring the business, there'd be a simple device in place for employers to escape the application of 197. So you can assume responsibility for a contract and run the contract using employees from some other entity, and then come the time of the transfer, simply escape liability by saying, oh well, yes, I'm the outgoing contractor, but those aren't my employees. 197 doesn't apply. Right, if we could have the next slide, please. This decision in Sodexo Southern Africa Pty Limited versus Olives and Plates Food is similar to the one in TMS Support Services or TMS Industrial Group, where here you had an outgoing contractor who's responsible for restaurants in the premises of MultiChoice, so throughout the country. And the contractors there are responsible for purchasing and preparing and serving food and drinks via the menus at the various restaurants and coffee shops. Now the restaurant facilities were all provided by the client, by MultiChoice. So the premises, the furniture, the kitchen equipment, etc. was provided by the client. The service provider provides the service using its resources, I suppose the consumables and the staff. And here again, contract gets lost. New contractor comes in and says, look, I'm not taking over anything from the outgoing contractor. Everything belongs to the client. I'm just stepping in here. The question again arose, well, does 197 apply in those circumstances, and the court was quite willing to accept that it did. It was of the view that these catering services constituted an economic entity. They were discrete entities comprising the various business components, and that the incoming contractor would perform the same services that were previously provided, using the same infrastructure to the same client. Effectively, it looked like the same business as in the hands of the outgoing contractor, and 197 was found to find application. There was another case involving Sodexo and Servest by acting Judge Barnes, which was decided in the Johannesburg Labour Court, and the outcome was to the same effect. Now that it could perhaps be contrasted with, if we look at the SVA security decision, where the issue was the provision of security services to Macro nationwide. And what happened here was, while the security services were provided at the premises of the client, and that would be the same for the outgoing and incoming contractors, nothing was transferred from the old security company to the new one in terms of equipment, intellectual property, any kinds of assets, tangible, intangible assets. They did offer, the incoming contractor did offer to employ some of the employees of the outgoing contractor, but after they'd gone through a proper recruitment and selection process. So there wasn't even any certainty as to how many employees were going to go across from the one employer to the other. The court said here, interestingly, not so much that there wasn't a transfer as a going concern, but that there was no business shifted from outgoing to incoming contractor. If all that shifted was the place at which the services were provided, that wasn't enough to constitute a transfer of a business, let alone a transfer of a business as a going concern, and the application of 197 was rejected on that basis. And the court reiterated this theme, which comes through many of the decisions, that given what was given to the incoming contractor, it wasn't put in a position where it could continue to seamlessly provide the services in the contract with the client that the outgoing contractor had been providing. And then, if I can go to the next slide, there's an interesting decision which you may well be aware of in Mvula Quality Protection Pty Limited and others versus UNISA, where as a result of the sort of fees must fall protest action, where one of the demands was that workers who had been outsourced should be insourced, or should be employed by, in this case it was UNISA. UNISA agrees to insource the security guards, in the sense that to employ the security guards as its own employees, but it concludes a shared services agreement with a new security service provider to come in and manage the security function. So it doesn't take charge of the security function itself. It doesn't start to sort of get into the business of security. It doesn't take over any of the equipment that was in the hands of the outgoing security service provider. All it does is it takes over all the employees. Now, there are two ways to approach this, I suppose. The one is to say, which is to ask yourself whether the group of security guards in and of themselves can constitute a relevant business. My suggestion would be, as an advocate, I'm so used to saying in my submission, my suggestion would be that they couldn't in and of themselves constitute a business that could be transferred. The court didn't decide the matter on that basis, though. The court accepts that in principle, the transfer of a business as a going concern must incorporate, while not all the assets, at least some of them, and at least some of the employees. Those which are, as I've indicated earlier, which are essential to the business as it was operated by the transferor or the outgoing contractor. And again, that the incoming contractor should be put in a position where it can seamlessly operate the service or provide the service after the transfer. So here, all that had happened was UNISA took in a range of employees who were previously employed by the outgoing security company, enters into employment contracts with them, but that's where the similarities ended. There's no security business being run here, not in whole, not in part. No equipment comes across, as I've indicated. None of the tasks or the functions were taken over by UNISA, and therefore in the circumstances 197 can't apply. It's a fairly unique set of facts though. It's not often that one is going to come across this where the person who voluntarily takes over the entire workforce but doesn't also simultaneously take over the function that was being provided by the outgoing contractor. Okay, if I could move on to the next slide. So if Mvula was about taking over a workforce from an outgoing contractor, I recently came across this decision in NUMSA versus Sachs Packaging, where an employer decided, so the employer was a manufacturer of paper bags, and it had effectively had a production line of employees performing various tasks, and it characterized certain of them as non-core and others as core. The difficulty being, of course, that the employees tended to move quite seamlessly between core and non-core tasks, so it was a bit unclear which ones they were primarily or substantially responsible for. Anyway, at some point, the employer decides that it's going to outsource these functions, and it elects to do so with a particular service provider. Now, that service provider is going to operate from the same premises. It's going to lease all the equipment from the primary employer, the client. So it uses the client's equipment and machinery for the sort of supposed non-core tasks. The client will provide it with all the raw materials and will invoice the new service provider. Now, effectively, what was going to happen, it seems, is that the service provider was going to come in and take responsibility for the employees, and it was made to look like it was going to provide some kind of service. Now, what's interesting here is that the court indicated a reluctance to accept what it called a definition of going concern that doesn't envisage as part of the concern a relatively stable set of employees who more or less perform only the functions of the business being transferred. So in this case, as I've indicated, the employees moved often between core and non-core. It was only the non-core that was being outsourced. And the court was of the view that you can't talk about a going concern where employees are moving in and out of the functions which are being shifted. Now, perhaps it might have been more sort of technically correct to say that what we're concerned with here is not a business for the purposes of 197, because it's not this sort of clear, discrete set of things which is being shifted. There seems to be a lot of fluidity and a lack of clarity around what the particular entity is and what's comprised in that entity. And on that basis, there's no business, and therefore 197 can't apply. I think effectively what the court was trying to do here was to say, look, I'm not saying this is a sham, but actually it seems like you're trying to use 197 to shift the responsibility of your workforce to somebody else. And that brought to mind the second of the judgments which I referred to on that slide, and that's the Starman Automatic CC one, which was decided way back in 2003 by Judge Landman. And what happened here was that Starman Automatic produced components for the electronic and automotive and construction industries. And they had, there was 44 employees, and most of them were carrying out its core functions. So there were machine operators and general workers represented by NUMSA. At some stage, they take advice from an organization called JobMates Labour Services Pty Limited, and they decide they're simply going to outsource their employees. And so they do, or they purport to. And they inform their employees that they're transferred as a going concern to JobMates Labour Services, which is a labour broker. And obviously, NUMSA brings an application trying to prevent or set aside this purported 197 transfer. And the question arises, obviously, does 197 apply? And the court says here, well, the services of these employees, the sort of labour that they provide, is not an economic entity that will retain its identity after the purported transfer. So this is not a business. First of all, it's not a stable economic entity which comprises these employees and the services and various other bits of business components. And similarly, the court seems to indicate that this is it's whatever transfer is going to happen here won't be one as a going concern. So here, similarly, the concern is to prevent employers resorting to 197 as a way to undermine protections to employees and absolve themselves of responsibilities to their employees by making those responsibilities someone else's. And then if I could go to the next slide. There's a recent decision in Communication Workers Union versus MTN South Africa, where the court was faced with an application by the trade union looking for information and consultation in the course of a Section 197 transfer process. The union said to the court, well, 1976 provides unions and employees with a right to negotiate with employers and for employers to disclose relevant information in the course of facilitating those engagements. You might recall that 1976 governs an agreement between the person responsible for the employees, either a trade union or an employee representative, and the relevant employers, the old and new employers, to vary the consequences of Section 197. And there's no limitation on the extent to which 197 can be varied in terms of 1976. But unfortunately, it doesn't provide, as you're no doubt aware, any obligation on any of the parties to negotiate, consult, and disclose information in the normal course. It's a tool which can be used by employers and employees and trade unions to vary the application and the consequences of 197 in order to make its application more suitable for their particular context. So the court finds, obviously, as it had to, that the reliance on 1976 is misplaced. There's no right to consult or negotiate or to request information in a 197 transfer process. And there certainly wasn't in this case. So the application failed. It's interesting, I wrote an article many years ago now on procedural fairness in the context of Section 197 transfers, and my recollection is that it might have been this union or perhaps a chemical workers union that brought an application against BP in the context of a 197 transfer along similar lines, also trying to seek information and oblige an employer to consult. And again, they were unsuccessful there too. And the question that I would pose is how acceptable this is in the context of 197, of our 197. Obviously, it's not going to happen in practice, or one would hope that it didn't. That in the face of an impending Section 197 transfer, that employers are going to simply not inform their employees around what's going on and not engage with them, but they're not obliged to. My suggestion is that there should be an amendment to the section at some point to make provision for consultation and information disclosure in and around Section 197 transfers. It's something which I think sort of properly balances, to the extent that it's possible. Obviously, the issues around business confidentiality in relation to commercial transactions and all of that. But making provision for something like that, for engagement and disclosure of information, would certainly balance 197 a bit more as far as sort of the right to fair labour practices is concerned. And it would also be in keeping with the experience overseas. So, for example, in the United Kingdom too, they have fairly detailed regulations around engaging with employees around 197 transfers. And as I've indicated earlier, disclosing information relating to 197 transfers. And I'm curious as to whether we can't introduce something similar here, but again, it would have to be by way of legislative amendment, because it doesn't exist at the moment, and the courts have shown no appetite to try and develop it somehow. And I'm not sure how one would do that. Okay, so flat my story is 8, as they say. That's a sort of a fairly rapid cook's tour through some of the more recent cases that are emerging in and around the application of 197. And I'm curious to know whether there are any questions. I don't know if you know how to ask questions. Oh, I see there's one from Daniel. He says, I don't know if you can all see this. It says, when an employer already outsources a specific function, however, employs some employees to provide the same function, would transfer of this function in totality to the service provider without transfer of any equipment, intellectual property be regarded as a transfer in terms of section 197? It says, note, employees cannot be transferred on the same terms and conditions as the service provider employs its own employees at much lower rates. In addition, the service provider is in a different province. I suppose there are two questions there. The first is this a 197 transfer? When you, well, so the incoming employer already employs employees to do the same function. Let's assume it's a 197 transfer. The question then arises, well, if you've got your own employees doing the same things, and particularly at lower rates, what do you do? If it's a 197 transfer, there's very little one can do on the face of it in terms of not taking the employees on. You can try and enter into a 197.6 agreement, which, as I've indicated, allows parties the opportunity to vary any of the consequences of 197 that would otherwise follow. So you could, for example, and it has to be by agreement, you could, for example, provide that none of the employees will transfer from the old employer to the new one by virtue of 197, or that none of their benefits will come across, or that their remuneration will be different. But again, that has to be done by agreement between the relevant employer and the employees. If that agreement isn't reached, then the employees come across to the new employer on the same terms and conditions, and those must be honoured. It sounds like in this situation you'd be sitting with a surplus of employees and the problem of employees who earn a lot more than the employees the incoming or new employer already has. So you probably have to enter into retrenchment discussions fairly soon. Either it's been suggested to me you can start your retrenchment discussions before the transfer happens already, if the 197 transfer is inevitable. Alternatively, after the transfer, you'll be sitting with a surplus of employees, and you've got to start consulting around how to streamline your workforce to make it suit your operational requirements. And I think that would apply whether or not the employees are earning too much, or you've got a surplus of people. The difficulty that you confront, though, particularly if you've got a surplus of employees, is who do you retrench? Because I think often the automatic assumption is that you just retrench all of the incoming employees, because then they're technically not your employees. The difficulty with that, though, of course, is that 197 has as one of its consequences that all the years of service that employees had with the old employer transfer to the new employer. So the new employer must treat them as having been its employees for all the years that they worked for the old employer. So if you're in a retrenchment exercise and you're applying the sort of often used criteria like LIFO, you're going to have to retrench some of your own employees in all likelihood before you can retrench those who are coming in. So if you're sitting with a problem like this where the terms and conditions don't suit, or you're sitting with surplus employees, your options are really to try and facilitate an agreement in terms of 1976. Alternatively, you might have to resort to some kind of retrenchment process. There's a question here relating to won't a consultation be compulsory in light of POPI and employees being required to give informed consent for their personal and special personal information to be transferred to the new employer? Well, that's a good question. Look, I can't profess to be an expert on POPI. I imagine that it would have the effect of limiting what information can be disclosed relating to particular employees, and maybe there are ways around that in terms of regulating how easy it is to identify particular employees in relation to the information that's being disclosed. But I imagine, yes, that there would in all likelihood have to be some kind of facility or arrangement made for what information can be disclosed and how that information might be disclosed, and it might well necessitate the consent of employees. It's a very good question, and again, I'm not an expert, and it's something that's probably worth exploring sometime soon in the future. Are there any other questions?
Craig, thank you very much for there seems to be no further questions. Thank you as always, Craig. You completely just a moment.
Oh, sorry. There's one more from Daniel again. If I might just deal with it quickly. He says the last question, I promise. I'm certainly not averse to more questions if you aren't. He says that a previous company dismissed who inherits a CCMA case. The simple answer is the new employer does. Again, unless there's some kind of arrangement made in terms of 1976. You'll see if you look at 1972 that the new employer takes over all the rights and obligations that existed between the old employer and the transferring employees, including responsibility for unfair dismissal, unfair discrimination, and unfair labour practices. So the new employer, it goes to show why proper due diligence is important in this context, because you may well end up being saddled as a new employer with claims for automatically unfair dismissal, for unfair discrimination, etc., that you had no idea that you were in for. And the old employer is completely off the hook because 197 has divested them of responsibility and placed it solely on the shoulders of the new employer. And it is only the new employer that is liable. The old and the new employer might have entered into some kind of indemnity between the two of them relating to potential liability under 197, and that's a contractual arrangement between them in terms of who can hold who liable. But as far as liability to the employees is concerned, for things like unfair dismissal, it's only on the new employer. Okay.
Thank you. No further questions. Craig, thank you very much as always for your input. Thank you to everybody countrywide for tuning in, and we hope to be speaking to you soon. And a very good night to everybody. Thank you very much.
Thanks very much.